Case 73, Rubin versus United Airlines. We find ourselves in the California state court system, more specifically, the California Court of Appeals for the 2nd District. Facts. These are quite lengthy, so please bear with. The appellant, Miss Adrienne Rubin, decided to join her husband, Stanford Rubin, a trusts and estates attorney, who was then in Hawaii. She purchased an airline ticket from respondent United Airlines. She paid for a coach ticket and upgraded the ticket to first class by using her husband's frequent flyer miles. On October 28, 1998, Miss Rubin arrived at Los Angeles International Airport approximately an hour before the plane was scheduled to depart. She went directly to the gate with her bags. She waited in line a long time before she could present her ticket to the agent at the gate. Miss Rubin had a first-class itinerary card with a seat designation of 2F. However, the United computer showed no first-class reservation for her. The agent explained Miss Rubin needed to surrender an additional 3,000 frequent flyer miles to qualify for a first-class upgrade, because for some reason, 3,000 miles had been recredited to her husband's account. The agent directed Miss Rubin to the customer service counter nearby. Approximately 30 minutes remained before the flight for Hawaii was to depart. It took nearly 15 minutes for Miss Rubin to reach the front of the line at the customer service counter. When the United agent finally located Miss Rubin's frequent flyer account on the computer, she discovered Miss Rubin did not have the needed 3,000 miles in her account. Miss Rubin told the agent to take the miles from her husband's account. Only 10 or so minutes remained before the plane was due to take off. The agent told Miss Rubin to go to the gates while she continued to try to locate Mr. Rubin's frequent flyer account number. Miss Rubin went to the gate and told the gate agent she had a first-class seat and wanted to board. The agent responded all first-class seats on the flight had already been assigned. He explained the flight was very full, but 2 or 3 seats were available in the coach section. The agent offered Miss Rubin the option of taking one of the seats in coach or flying first class on a later flight. He apparently did not indicate a specific coach seat assignment. Miss Rubin explained she had to leave on this flight because she and her husband had an engagement later in the day and she did not want to miss. Miss Rubin was adamant about wanting a first-class seat and on this flight. The gate agent notified the service director on board there was a person about to board who was insisting on leaving on this flight and insisting on a first-class seat. The service director decided he would at least accommodate Miss Rubin's wishes to leave on this flight. The service director met Miss Rubin in the jetway. Miss Rubin told the service director she had a first-class ticket, a seat assignment of 2F, and could not understand why the airline had given her seat away. Miss Rubin told the service director she had to fly first class because she had a special diet. The director reiterated all first-class seats were now assigned and occupied. He explained if she wanted to take this flight, she would have to fly coach in seat 26B. Miss Rubin entered the plane. She did not go to 26B in coach. According to Miss Rubin, the service director did not specify any particular seat, but told her she could sit anywhere in coach. Instead, Miss Rubin entered or attempted to enter the first-class cabin to determine for herself whether seat 2F was in fact occupied. As the service director put it, that's when the hair came up on the back of my neck, because you're violating everything that it's about, because it was clearly stated to Miss Rubin that the first-class seats were full. The purser of an aircraft has primary responsibility for the safety of the passengers and has ultimate authority over the other flight attendants. When she saw Miss Rubin enter or attempt to enter the first-class cabin, the purser, according to Miss Rubin, went ballistic. Miss Rubin got into a lengthy and loud discussion with the purser. The service director intervened and again directed Miss Rubin to take her seat in 26B. Instead, Miss Rubin dropped her luggage in the doorway of the aircraft and took a bulkhead emergency row seat immediately behind the first-class section. The service director told Miss Rubin to store her bag. Miss Rubin refused and told the director he could do it himself or have someone else store the bag if he wished. The service director and another stewardess repeatedly told Miss Rubin she could not sit in row 9 either, both because she had been assigned seat 26B and because she was not emergency row qualified. The service director left to consult with the purser. The purser, in the meantime, had already talked to the captain. The purser told the captain she had an irate passenger on board who refused to follow directions and who had attempted to make an unauthorized entry into the first-class section. Based on the purser's representations, the captain agreed Miss Rubin's demeanor and refusal to follow directions had the potential to create a safety problem in flight. The purser told the service director she would not fly if Miss Rubin remained on board. The captain, purser, and flight and service director decided Miss Rubin should be deplaned. When the service director returned to the cabin, Miss Rubin was no longer sitting in row 9. She was instead sitting in another person's seat who had been in the lavatory. The person whose seat Miss Rubin occupied was now sitting on the armrest of an aisle seat. The service director told Miss Rubin she would have to deplane. In response, she instead finally took her assigned seat in 26B. By this time, the flight was at least 15 minutes past schedule for takeoff. The other passengers were becoming impatient and unruly. Some yelled at United personnel, suggesting they do something to regain control of the situation. A gate agent came on board to take Miss Rubin off the plane. Miss Rubin was talking loudly on her cell phone. She refused to acknowledge his presence or mission. He could not get Miss Rubin to pay attention to him or to stop talking on the telephone. He left the plane in frustration. Now the flight was some 20 to 25 minutes past departure time. United personnel decided to call the Los Angeles Airport Police. Passengers started applauding when the police officers boarded the plane. The Los Angeles police officers asked Miss Rubin to leave the plane. Miss Rubin kept interrupting to explain she believed she had a first-class seat assignment and could not understand why United had given her seat away. The officers told Miss Rubin the airplane was not going to take off with her on it. Miss Rubin refused to leave the plane voluntarily. She refused to leave her seat, refused to stand up, and refused to walk. The officers had to pick Miss Rubin up out of her seat and carry her by her shoulders off the plane. As they proceeded in this fashion through the aisles, passengers applauded and whistled. They also yelled and hurled wads of paper at Miss Rubin. In the view of one officer, the situation on board was a mob scene. He believed the other passengers were so frustrated and upset with Miss Rubin because of the trouble and delay. He believed if United had permitted Miss Rubin to stay on the flight, it could have gotten ugly. The officers took Miss Rubin off the plane. Her luggage was still where she had dropped it in the doorway. The service director moved her bag to the jetway. The officers detained Miss Rubin at the police station for several hours. The officers contacted the FAA and the FBI, as is required when investigating a potential federal charge of obstructing a flight crew. A representative from the FAA arrived and interviewed Miss Rubin, as did a sergeant from the Los Angeles Police Department. Ultimately, Miss Rubin was not charged. The officers returned Miss Rubin to the airport, and she flew first class on the next flight to Hawaii. Miss Rubin filed suit against United, the City of Los Angeles, and the Los Angeles police officers who removed her from the plane. Her complaint alleged causes of action for false arrest, false imprisonment, unlawful search and seizure, assault, battery, and emotional distress. United moved for summary judgment, claiming Miss Rubin's state tort law causes of action were expressly preempted by the Airline Deregulation Act. In the alternative, United claimed it was entitled to judgment as a matter of law in any event, asserting it had acted within the broad discretion accorded airlines by federal law to decide when a passenger presents a security risk sufficient to be removed from a flight. United argued there were no material factual disputes and asserted it was thus entitled to judgment as a matter of law. The trial court granted United's motion, and this appeal followed. The issue: whether the trial court correctly granted judgment in United's favor and dismissed the action. Holding: the judgment was affirmed. The appellate court concluded that the trial court correctly granted judgment in United's favor and dismissed the action. Let's look at the reasoning. The court began by inquiring whether the state court claims at issue were preempted by the ADA. The ADA prohibits states from enacting or enforcing a law, regulation, or other provision having the force and effect of law related to a price, route, or service of an air carrier. This case concerns the scope of this preemptive provision as applied to a suit raising state tort law claims regarding, as United alleges, claims arising from its boarding procedures. United claimed boarding procedures were classified as a service, and state claims challenging this airline service were expressly preempted by federal law. Mrs. Rubin, by contrast, claimed that the airline gives a too all-encompassing reading to the term service. She argued Congress used service in the public utility sense to only refer to the provision of air transportation to and from various markets at various times. She asserts her claims do not affect these services and thus are not preempted by the ADA. Ultimately, the court decided that it did not need to decide which of the competing definitions of service most accurately reflects Congress's intent, because regardless of the types of state claims which should be preempted under the rubric of services in the ADA, the court concluded that United properly exercised the discretion given it in Section 44902 of the FAA to refuse Mrs. Rubin passage in the circumstances presented in this case. Section 44902 of the Federal Aviation Act permits mandatory or permissive authority for an airline to refuse to transport a passenger or property the airline decides is or might be inimical to safety, as follows. A. Mandatory refusal. The administrator of the FAA shall prescribe regulations requiring an air carrier, intrastate air carrier, or foreign air carrier to refuse to transport 1. A passenger who does not consent to a search under Section 44901, establishing whether the passenger is carrying unlawfully a dangerous weapon, explosive or other destructive substance, or 2. Property of a passenger who does not consent to a search of the property, establishing whether the property unlawfully contains a dangerous weapon, explosive or other destructive substance. B. Permissive refusal. Subject to regulations of the administrator, an air carrier, intrastate air carrier, or foreign air carrier may refuse to transport a passenger or property the carrier decides is or might be inimical to safety. Congress originally enacted this provision to help combat an air piracy problem. However, Section 44902 is not, as Ms. Rubin suggests, reserved strictly for would-be terrorists and hijackers. Airlines have also invoked their discretion under this statute, as they have under common law, to exclude passengers in any number of circumstances. As the Second Circuit noted in Williams v. TWA, an airline's duty to perform its services with the highest possible degree of safety in the public interest has both a statutory and common law basis. All commercial airlines are common carriers and as such owe a duty of utmost care for their safety. On the other hand, although the discretion gives an airline under this provision to refuse to transport a passenger for safety reasons is decidedly expansive, it is not unfettered. If an airline's refusal of transportation is arbitrary or capricious, its refusal can give rise to a claim by the offended passenger for damages. Stated another way, the decision to accept or refuse transport to a passenger based on considerations of safety and security lies exclusively with the air carrier, and if such discretion is exercised in good faith and for a rational reason, it will be upheld. Although a pilot necessarily relies in part on the purser and operations director in the making of the decision to deplane a passenger, a pilot has ultimate responsibility for the overall safety of the aircraft, its crew, and passengers.